Z Studios. Mark Walters in front of this Patriot Mobile Platinum and very powerful microphone. Wishing you a great Friday today. It's Greg's favorite day of the week. Greg in Dallas, Texas, how you doing today, my brother?
Not too bad, yeah. TGI Friday.
TGI Friday, Greg's favorite day of the week for sure. Let's get my mic turned up in here. Good, there we go. I was going to hear myself a little bit better. We got a lot to talk about today. Those of you who listen to the show and watch the show regularly usually expect to hear Paul Markle here on the broadcast on Fridays, but Paul is driving through the mountains today with no signal, so we've given him the day off, and we've got a lot to talk about. Guys, I was on the press conference today with Ken Cuccinelli, former Virginia Attorney General. We're going to be talking about that on Sunday, but I might get into some of that with you in the fourth segment because we've got John for segment 1, 2, and 3. John, welcome in, my friend. How you doing?
Doing great. I was actually the expert for Ken in the case that he was arguing in Virginia on the assault weapons ban there. So we'll have to see how that works out. But anyway, it was fun doing that. Kind of a crazy weekend this last weekend because he called me up on Saturday, and I basically had to get my report in by Sunday evening. So,
well, the take that he's using on the approach on this is interesting because he's using Virginia's very strong militia clause. So the assault weapons ban case is what we're talking about, ladies and gentlemen. The assault weapons bill is really the one we're focusing on here. This law goes into effect in about 12 days or so, 13 days, something like that. It goes in on July 1st, whatever that math is, whatever day today is. I'm not even paying attention. But on July 1st, that unconstitutional bill banning your right to bear arms, particularly what they define as assault firearms, John, as you know, takes effect. And it is a ban, and they're using very strong state language on the approach. The press conference today was quite fascinating. And as I said, ladies and gentlemen, I've got the transcripts in front of me, and maybe we'll dig a little bit deeper into that in the fourth segment. John, let's talk first off about the weed case yesterday. We're calling it the weed case. Let's talk about the Hemani decision. That was huge for a lot of different reasons. And before I give you my opinion on that, I'd like to get your thoughts on that case.
Right. Well, I mean, it was pretty surprising. There were some people who thought we could lose that. It was not the preferred case that a lot of people would have liked to have taken to the Supreme Court. You know, it's kind of like bad cases make bad law type of way of labeling it. And here you had a guy who was a criminal. You don't like unsympathetic people going before the court because, you know, a number of the justices understandably aren't too thrilled about being nice to criminals. But it was a 9-0, it was a unanimous decision, striking down the prohibition on people who were using marijuana from being able to go and have guns. And Gorsuch wrote an incredibly strong decision, and I think it cleared up whatever ambiguity, and I didn't really think there was a huge amount, but in the Rahimi decision that they had been forced to do, another case where you had somebody who was a despicable person, someone who had shot at people, had beaten up his girlfriend and stuff like that. In that case, though, he had been adjudicated, had essentially agreed in court that he was guilty of those crimes. And so that was an important point that Gorsuch kept on hammering away at in this decision. But so here's the issue in this case, and that is up until the Trump administration, marijuana was classified as a class 1 type substance, which basically means it has no redeeming features. And whether or not, if something is classified that means if you're using it, then you're committing a crime. You're not allowed to go and own guns at all, even if 40 states in the United States allow people to be able to go and use marijuana on different levels. And what the government wanted to go and argue is that, you know, if you were taking something like marijuana, you'd be impaired and not be able to go and function properly. And Gorsuch, I thought, did a very good job on this. He basically, and if you ever listen to the oral arguments, they're pretty entertaining. You know, he was saying, look, you look at the history, a lot of the founding fathers drank regularly. You had like John Adams having like a pint of whiskey in the morning with You had somebody like Thomas Jefferson saying that he didn't really drink very much. He only had like 6 glasses of wine with dinner.
Yeah.
And, people don't realize that kind of before we really had refrigeration, people basically used alcohol to keep things from going bad, to go and make it so that you didn't have bacteria or other things, little amoebas swimming around in what you were drinking. And so a lot of people basically had alcohol with all their different meals. And what Gorsuch made clear is that, look, in this case, all the individual had done was tell the police that he had marijuana once every 2 days. There's no evidence that he was impaired in any way. Gorsuch makes it clear that if you look at the historical analogs there, people were only really banned from having guns if they were so inebriated that they weren't able to properly function. And it was often done in order to protect financially rather than go and deal with restrictions on gun use. And the Rahimi case, where he's bringing that in again, is just you have to have adjudication that the person is a danger to themselves or others. And simply having the police be told that the guy uses marijuana once every 2 days, that didn't meet any of the criteria that was there. And so you got all the justices to agree. Now, I will say one warning that people should have, and that is one of the concurring opinions by Justice Jackson and Sotomayor, while they agree with the bottom line on people who have marijuana shouldn't be banned from being able to go and have guns, they, in their concurrence, took a lot of issue with using Bruen for doing that, because they said, they don't like the fact that you should just look at the history. They said that was arbitrary. They wanted to have what's called a balancing test, where a judge or the justices would kind of go in their own mind and weigh the relative benefits versus the costs. And to me, that seems a lot more arbitrary and a lot less able to predict what's going to happen with those things. But, after the Heller decision, you had courts across the country that were using these balancing tests. And time after time, when they were using these balancing tests, they would go and uphold different types of gun control laws, because you'd have liberal judges who would go and say, well, we think the benefits from these gun control laws outweigh costs. And that's what the Democrat justices on the Supreme Court would like to go back to. And the problem is that should at least be a warning sign to people that if the Democrats, when the Democrats get back in charge, you basically have virtually all the Democrats on the House Judiciary Committee want to pack the Supreme Court, at least all but one of the Democratic senators want to pack the Supreme Court. And so, you're going to, if you have 13 or 15 justices, as they're talking about, it's going to be pretty clear that the new justices that they're going to have are going to have similar views to Jackson and Sotomayor.
And it would wipe out our Second Amendment as we know it. I have a lot to unpack with John. Ladies and gentlemen, we're getting ready to take our first break. I've been taking some notes. John, just so you know, before the break, I took a deep dive into this. You've already touched on some of this that I talked about yesterday. We're going to go there. I can't wait to get your perspective and some of my thoughts. And something I didn't mention yesterday, ladies and gentlemen, stick around for this one. I asked a good friend of ours, who I won't name, his thoughts on what I'm getting ready to mention to John when we come back. And I'll tell you what he had to say, this unknown person. We'll be right back with John. Don't go away. Back in, a bunch of things to talk about. First of all, KJB's concurrence on this was fascinating. Number one, I'll get to that in a second. But I've got to ask you this question. This popped up yesterday during a conversation I had, John, with, I'm only going to say, because I don't want to put words in his mouth, and if I get him on the show, I'll let him talk about it himself. But somebody that you and I know very well and are close to, a powerhouse in the gun rights movement, and I'll just leave it at that. And I asked the question, is it possible, John, that the government appealed this to and sought cert at the Supreme Court, even though the Fifth Circuit in Texas had already ruled the same thing? Is there, the more I looked at this, I thought, the government had to know here. The Trump administration has relaxed the classification, as you were talking about. It used to be a class 1. They've relaxed that. Nobody's hammering the states. The feds are letting the states do what they want with marijuana, even though it remains technically illegal at the federal level. It's being relaxed. It might even go wayside eventually. I wouldn't be shocked to see marijuana be legalized across the country, even at the federal level at some point. I don't know when, but it's certainly possible. Could it be that they sought cert in this case because they wanted this decision? Could that possibly be an angle? I'll just say that our good friend agreed with that and said that's a very strong possibility that the government did this because they knew how it was going to be ruled on. You think that's possible?
I don't think so. I mean, there are other cases that they could have surely brought that would have had more sympathetic type litigants involved. And, I mean, admittedly, I think they had a hard line to argue with in the case, but, you listen to the oral arguments and you go and you read the evaluation after the oral arguments. And I guess, I'm shocked that it was 9-0. I mean, it's easy to go and do Monday morning quarterbacking afterwards, and people can say you should have seen this. But I look at that and it's not obvious. There are many prominent scholars who follow these cases thought that there was a chance we could lose this 5-4. That Alito in the oral arguments was hostile to, or let's put it this way, was supportive, seemed very supportive of the government's arguments that were there.
He did. I agree.
It seemed like, you had the 3 Democrats who could have said, look, we don't think, we want marijuana to be legal, but we don't, we hate gun rights too at the same time. And Roberts could have gone that way. So, it's not obvious. Just listening to the oral arguments and reading, if you read a lot of the evaluation of the oral arguments, people were saying could go either way.
Yeah, it's interesting.
I think few predicted it was going to be 9-0. I don't know. Maybe you can find somebody who predicted it would be a 9-0, but there weren't many like that.
I didn't think that. I thought it might have been 6-3 or 7-2. In fact, I was talking with Jared Yanis about literally 5 minutes before it came out. My guess would have been at best 7-2. But, this just highlights, ladies and gentlemen, if you've ever watched the oral arguments at the Supreme Court, and I would highly recommend you do, regardless of the case, it's quite fascinating, and it just highlights how difficult it is sometimes, probably, John, more often than not, to determine how a case is going to go based on questioning, because we've seen questioning like this before from somebody like Alito, who, if I was a betting man, I would have said it could have been 8-1, and it might have been Alito because of his line of questioning. So you just never really know. But let's go to KJB's concurrence. I found this interesting because it's right in line with what we're talking about here. She made the comment that she agreed with this decision because of its alignment with the precedent in Bruen. And then threw the but in, kind of like, well, I support the Second Amendment, but she understood the precedent in Bruen, but had to make it clear in her concurrence that she disagreed, as you pointed out in the first segment, with Bruen, and that's what led to they wind up packing the courts. But she at least acknowledged the precedents in Bruen. So my deep dive on this yesterday, the bottom line was this absolutely strengthens Bruen going forward.
No, I don't think so.
You don't? Tell me why. Tell me why.
She says all she's saying is that she's not surprised that the majority ruled the way they did because of Bruen, but she made it very clear that she doesn't accept Bruen as good precedent. So if you had 5 members of the court who were like her and Sotomayor, they may have said, sure, people can go and own guns, but we're going to, who are using marijuana, but we're going to go back to these balancing tests that were there, where we get to decide whether we think the benefits from people owning guns are better, or outweigh the costs that are there. And it's pretty clear, just like,
it definitely is. I agree.
Surely remember the cases after Heller. There was one court case after another around the country where they would go and strike, support different types of gun control laws because those liberal judges said that the benefits of the laws outweighed the costs. And so she would move back to that type of regime. So she would, what it appears like she would go and say, look, Heller has certain logic to it. She never talked about Heller. So she would get Bruen. Now, to me, Heller and Bruen were pretty much the same. Both of them were basically not relying on balancing tests. It's just that judges around the country didn't want to, I guess, understand that. And so Bruen had to make it doubly clear that, we just think, you read what's there and you go from that.
Yeah, when we come back, ladies and gentlemen, I want to go a little bit further into that with John. I find his answer on that fascinating for a lot of different reasons, and don't disagree with you, John, at all. It's clear to see where you're coming from in that. Guys, we've got John for one more segment, so we're going to move quick. Buckle in the next segment. We'll be right back. AAR. Let's go back to Dr. John Lott. John, a bunch of I wish I had more time with you. I really do. I know you're going, and I know you said you were going to be out of the country. Guys, that's why I really wanted John on the program Sunday. His schedule wouldn't permit it, so we've got him today, and we'll just cut up snippets and get them all over social media for you over the weekend. In the meantime, John, I find the conversation about, Greg and I were talking about the Fifth Circuit and why didn't the government leave it alone, and talking about KJB, and I agree with everything that you said. However, I think in the long run, we've got the Woolford case coming out, and as you know, there's about 20 cases that are lined up relative to guns to a certain degree and a certain extent before the Supreme Court. Clearly, they're not going to take them all. In the short term, sans a packed court, do you think these cases that we win, because obviously I think you and I are in agreement that we will win the Woolford case in Hawaii hands down. If we get an assault weapons ban case, we'll win that. And to me, that seems to me, in the short run anyway, at least with the current makeup of the court and into maybe the next election or past, if we can keep the White House and the House and Senate, that maybe it strengthens. That was my take on that. I'll give you the final word, and then I got to talk to you about Canada. Go for it.
Right. Yeah. Well, I mean, I think I'm optimistic. I think the Supreme Court is probably waiting for a decision from the Third Circuit on New Jersey's assault weapons ban.
Agreed.
They like to have circuit splits, and unfortunately, the states that have adopted things like assault weapons bans and many other types of gun control laws are in those federal circuits where the Democrats have controlled the circuit because of Trump's appointments to the Third Circuit, which includes New Jersey and Pennsylvania. He's been able to flip control of that court. His judicial appointments have been probably the best from the Bill of Rights perspective of any president in my lifetime, even more consistent than Reagan's. And but they're probably waiting till the Woolford case comes down and wait till the Hamani case just to see if anything that the Supreme Court said in those cases would affect their decision on the New Jersey assault weapons ban. But once the Woolford case comes out on Hawaii, I think in relatively short fashion we'll see the case, the en banc decision from the Third Circuit come down. And when that happens, my guess is the Supreme Court will fairly quickly grant cert for an assault weapons ban case.
We need it desperately, John. We do. Listen, let me stop you there only because I really want to go to Canada with you, and we've only got about 4 minutes. The segments fly by. the numbers that you found in this study, ladies and gentlemen, take a listen to this. This will blow your mind. It did mine. John, Canada is a much more dangerous country than the United States. Take us to the break, man. This is fascinating stuff.
Right. Well, what you see is people go and compare reported crime rates, so the FBI data from the United States with the reported crime rates in other countries. And the problem is that can be very misleading. And, Canada, the last time that they did a national survey on crime victimization was in 2019. What they found was that only 29% of violent crimes were reported to the police. In the United States, that year was about 41%, and the most recent year that we have, it was about a little bit over 48%. But here's the problem. If you have only 29% of violent crimes being reported in one country and 41% of crimes being reported in another country, even if the crime rate, the true crime rate was the same in both countries, because the higher rate that crimes would be reported in the United States, if you just looked at the reported crime rate, it would make it look like the United States was worse. And so what we did was we kind of did kind of a deep dive trying to take that into account. And it's pretty clear that Canada has a much, much, much higher violent crime rate than in the United States. I mean, look, are homicides higher in the United States than Canada? Yeah, our homicide rate's about twice as high. But, when you're talking about homicides, it's like it's a tiny fraction of 1% of overall violent crimes involve homicides. It's about 0.2%. In Canada, it's about 0.2%. But the reason why it's so much lower in Canada is mainly because of the fact that they have so many other types of violent crimes like rape, robbery, aggravated assaults. And so the post that we have up on our website at crimeresearch.org kind of goes through how to compare the different measures that you have of crime. And I would argue that it looks like their violent crime rate in Canada is about 300% higher than the violent crime rate in the United States.
Yeah, we're not going to hear the mainstream press talk about that.
175% higher.
Those are crazy numbers. You never hear that from the mainstream media here. It certainly doesn't fit their narrative because they like to push how much safer Canada is and Canada's gun control and how effective all that. It just doesn't work for them, John. Those numbers are 295% higher, ladies and gentlemen. I want you to go read the study at crimeresearch.org. It's up right now. Go see that. John, that's were you shocked by that?
I guess I wasn't super shocked. I mean, there used to be something called the International Crime Victimization Survey, which gave a good measure across different countries. And in 2000, the Canadian rate was much higher than the U.S. rate, but it's gotten even worse relative to the United States compared to what was shown in that survey. But, it's just not Canada. We did earlier work that we haven't really talked about with Australia. In the United States, you have 45% of rapes and sexual assaults reported to police. In Australia, it's like 19%.
Wow.
Well, you just can't compare the number of reported crimes. And when you try to look at the measures of total rapes and sexual assaults, the rate in Australia is about 3 times higher than the rate in the United States. And I just had a piece in an Australian outlet with a federal senator down there that basically tried to go through those numbers.
Wow. John, it shocks me. I wouldn't have expected it to be 295% higher. I would have expected it to be higher with population figures and everything else. John, crimeresearch.org. Ladies and gentlemen, we've got to let John go. We're getting ready to take a break. John, thank you. Travel safe over the next couple of weeks. We know you're doing God's work wherever you're going to be. And ladies and gentlemen, when John is back in the United States, we will have him back on the program to talk about everything that he was doing. That's Dr. John Lott, crimeresearch.org. crimeresearch.org. When we come back, you've got me for the final segment. On a Friday, we're going to wrap up your work week for you. Don't go away. We'll be right back on Armed American Radio's Daily Defense. All right, so interesting conversation with John. He's got a lot going on, and I want to thank him for being here today. I know how busy he was, and he was kind enough to jump in and fill in for Paul today. John is always so spot on, but I'm gonna say this. I disagree with him on the fact that he didn't think Bruen, Greg, I thought was interesting, he didn't think Bruen was strengthened by a case, even when KJB admitted, and she said and used the words, respecting the precedent set, this court respects the precedent set in Bruen. Words mean things. Now, I mean, to a liberal wacko, she'll say what she wants and do something completely different. We understand that. John is absolutely spot on the fact that if given the opportunity to wipe out Bruen, she would do that, and that is what she said without saying it. Tell me the quiet part out loud in her concurring opinion. But we already knew that. There's no shocker there. And the fact that we've got another case coming up, and that's the Wolford decision, which I had hoped would come out today. We'll see it, ladies and gentlemen. It's coming out any day now. It's really a matter of hours when that decision flies. It'll be here by the end of the month. And that's going to be a win as well for Second Amendment issues. The wins are piling up. All of these wins strengthen the precedent that's leading us to these wins, is the point that I'm trying to make. But we will see. John is absolutely correct, though, folks. They will. If they can pack the court, they're going to do it. They'll wipe Bruen out in a heartbeat, which is why it is so vital that we don't let that happen. That's why you got to join your state organizations, even if you're in a red state. On another court front, this one down in Florida, I was talking, Greg, we hadn't had Sheriff Kurt Hoffman from Sarasota on in a while, have we?
No, we haven't.
Well, we need to change that.
Yeah,
because
sure.
Kurt sent me, he was the first one to send me the decision moments after it came out. Florida concealed carry ban for 18 to 20-year-olds ruled unconstitutional 2 days ago. I've been waiting to talk about this with you. We'll be going into this on Sunday with you. But a 3-judge panel for Florida's 4th District Court of Appeals ruled on Wednesday that the state's ban on concealed carry for 18 to 20-year-olds is unconstitutional. And I was looking at a New York Post piece on this, that the judges were unanimous in their decision, and Judge Spencer D. Levine wrote the majority opinion. He observed, and I quote, 18 to 20-year-olds can defend their country without restrictions, but can only utilize their Second Amendment right to self-defense with severe restrictions. Restricting 18 to 20-year-olds members of the same political community as other law-abiding adults, and those are the operative words there, folks, political community, from our right to self-defense would make the Second Amendment a second-class right. This burden on law-abiding 18 to 20-year-olds' right to public carry, and specifically here concealed carry, which is not applicable to any other adults, is a burden that is facially unconstitutional as to 18 to 20-year-olds. Wow. And, of course, Uttmeyer, the AG, this guy, I mean, Florida's been making some great Second Amendment moves lately, ladies and gentlemen. They have. I mean, you got the blues down there trying to ban you in the HOAs and all that nonsense, but at the state government level, where it really matters right now, here's what Uttmeyer had to say about that in an ex-post 2 days ago. In another win for the unalienable rights of Floridians, the 4th DCA, District Court of Appeals, agreed with our position that Florida's law banning adults under 21 from concealed carrying a firearm is unconstitutional. We will not seek further review, and we'll work with FDACS to implement the court's order. There you have it. That was a 3-judge unanimous decision in the state of Florida. So another huge victory. And also, as of Friday, 18 to 20-year-old West Virginians are able to legally conceal carry for self-defense without needing any permit or license from the state. Yet again, another throat punch to the other side. Those clowns are getting beat up at every single twist and turn. Are we winning the fight, ladies and gentlemen? Seems like it, until you move to other states and realize, oh, wait a minute here. We've got 17 or 18 states that just don't care. And, of course, the usual suspects in New Jersey, New York, California, Illinois, Maryland, and now, of course, Virginia, where the fight is, that is literally the battlefield. And that battlefield is going to play out nationally if the Democrats win, which is why we cannot let our guard down. We must stay on our toes. I mentioned this yesterday. As gun owners, as gun rights advocates and supporters, as supporters of the right to bear arms, as patriots, supporters of our Bill of Rights, we've been on defense on this issue for a long time. We are now on offense. Now is the time to put our foot on the gas. Now's the time to join those states, groups, organizations, vcdl.org, azcdl.org, Florida Carry. CCDL is free. Just go join them in Connecticut. Don't matter what state you live in, folks, join the organization. I don't care how blue your state is. I don't care how red your state is. Just get her done. Get her done. We've got a great show lining up for you on Sunday. The Monster Cast will be here before you know it. And I'll leave you with this today, only because it's fun, and I did use this in a YouTube video yesterday. Carry on, carry often, carry absolutely everywhere. Never, ever, ever leave your cave without your club. No self-respecting caveman would ever be caught outside his cave without his club. Enjoy your day. Stay safe. Enjoy your weekend. I'll see you on Sunday evening's Monster Cast.